Shea, good morning.
Good morning, Your Honors. I represent Parish Phillips, the co-appellant in this case. In the time available to me, I only want to address in detail one issue, which is the show-up identification of the defendant, Phillips. Before I get to that, I did want to comment that after my brief was filed, this court decided the Commonwealth versus DePace decision, which the Commonwealth has cited in its brief, which seems to control my first argument that the indictment did not state did not properly state first-degree murder and should have been limited to second-degree murder. I won't concede the point, but I do concede that it would probably require reconsideration of DePace.
Thank you.
With respect to the show-up identification, I think it's important to emphasize several points which make this an unnecessarily suggestive show-up. One is that the identifying witness, Sean Eccles, did not know Mr. Phillips in advance. He had not seen him before the incident. He was standing outside the house of the victim on the sidewalk, and he saw Mr. Phillips and another unidentified man go into the house. They walked past and went into the house. And then after the incident inside the stabbing and the individual the
Mr.
victim.
Shea, I'm sorry to interrupt you, but wasn't there evidence that he said he recognized him? Or am I wrong
I'm sorry.
about that?
He didn't know him he didn't know him in advance. He is not someone he knew in advance of the incident. He did identify him. He did identify him during the police show-up 20 minutes after the stabbing.
Oh, okay. I'm sorry.
But aren't show-ups permissible in circumstances such as these?
Well, the reason that this one is unnecessarily suggestive is that it has to be seen in contrast, in the context of how it occurred, which is the identifying witness was taken first to see three men.
Don't those circumstances make this much less suggestive because they went around to see different people?
They did, but the first three that they saw were clearly not in custody. They were standing, holding bags, which the witness thought that they had come out of a liquor store and were holding liquor bags. So they obviously were not. They were not so under suspicion by the police that they had to be restrained. The second identification was my client, and what the witness heard in the police cruiser as he went to the scene of the identification was that Mr. Phillips was being held, that he had a clothing which matched the description that the witness had given initially to police. The witness conceded on cross-examination that he did think the police had arrested a perpetrator before he got there based upon...
Mr. Shea, this is an area that we've looked at, in a number of different contexts. From your point of view, which is our case, or, an appeals court case, that gives you the greatest support?
I'm not... I don't think I could single out a single case that does. I'm arguing the specific facts of this case, which
within the existing jurisprudence.
Yes, which shows that the identification was unduly suggestive. My client was in handcuffs as he was taken out of a police wagon, to police on either side of him helping him down the stairs. A spotlight was shown upon him. So it was clearly the kind of a show-up that the police were communicating to the witness that this was somebody that they thought was the perpetrator, as contrasted with the first show-up of the three men with the bags in their hands, who were obviously not thought to be perpetrators, or at least was not very suspected of being. The last point that I wanted to make on this, which goes to the reasonableness of suspicion and probable cause, is that it is true that the police found a wallet in Mr. Phillips' pocket at the time they first seized him. However, they did not know that that was the victim's wallet until after the identification, the arrest and the identification. It was at the police station during the booking procedure that they discovered the identity of the wallet.
Are you suggesting that that the detention for the purposes of the show-up has to be justified by probable cause? Because,
Well, yeah, I did make the argument that
I know you did,
it's,
but and why is that so in this case and not others?
well, in this case, it was arguing that he was under, it was a question of whether the arrest was based upon probable cause.
Well, your argument is that he was arrested,
Yes.
then
And then showed
Mr.
up,
Eccles
yes.
identified him, as opposed to simply he was detained pending the identification.
Yes, that's correct.
Thank you, Mr. Shea. Mr. Bailey?
Good morning, Your Honors.
Good morning.
I appreciate the additional 5 minutes to make argument. If it pleases the Court, the evidence at trial was insufficient as a matter of law to establish Defendant Rice's guilt beyond a reasonable doubt on either the theory of joint venture murder or individual liability murder. Critical to this argument, and I will continue with the Court's indulgence to come back to this, is a review of the relevant facts in this case as they pertain to Defendant Rice. On January 11, 2000, Sean Eccles and Courtney Woods were outside a apartment building at 951 Blue Hill Avenue. Both had done crack cocaine the day earlier that day. The victim was already inside 951 on the second floor in an apartment. Courtney Woods?
Do you know does the record show how many apartments there are in 951 Blue Hill Avenue?
The record is unclear, unfortunately, Your Honor. All it says is the victim was in his second floor apartment. Rhonda Woods talks about going up to her apartment as well, so we know it was a multiple apartment building, but that's all we know.
Did the jury take a view?
I don't know. I don't recall if the jury took a view. That did not jump out at me in my review of the transcripts, Your Honor. In any event, Courtney Woods goes inside the building. So now we have two known individuals inside, the victim and Courtney Woods. Philip Rise, the defendant, arrives alone. He says hello to Sean Eccles, makes no attempt to hide his identity. Then he enters 951 alone, being led in by Courtney Woods. Now we know of three individuals inside. Eccles stays outside talking to Rhonda Woods.
Let me ask you a question, if I could. You analogized your case to Salemi.
Yes, I did.
If I'm correct now. But aren't there some differences from Salemi? If I remember Salemi correctly, there was only one shot, and also no one was thrown out of a window by a number of men. This was a number. So I'm wondering if that's really the same situation.
Well, we analogize to Salemi. First of all, it is a case where the Commonwealth abandoned the joint venture theory, so we look at it in terms of a comparison for the individual liability. The fact still is, Your Honor, that there are three individuals inside a restaurant, the defendant, another individual, and the victim. They are unobserved. That's the point, really the relevant factor while they're inside. The defendant, Salemi, was seated at the side from which the shot that killed the victim purportedly came. And then the defendant, Salemi, avoided all of his usual haunts and places that he frequented for a period of time. It's my position that that is relevant on individual.
Here, though, your defendant, he ran out of the building with the other two men. He didn't run out before them or after them. He also, according to what I read, was carrying something wrapped in a sheet. Query whether that was a gun or drugs, who knows, but it was probably something illicit, carrying something in a sheet. And doesn't that help to indicate that there's a joint venture here? And particularly the fact that he ran out with them.
Well, Your Honor, our position is nobody knows other than a crack addict who was outside said he saw the victim drop from the window by unidentified individuals. Nobody knows what happened inside that apartment in terms of Mr. Rise's movements, actions, or activity. He ran out. I submit to you that if somebody is...
No, he ran out he didn't run out before them while they were in the middle of shooting or in the middle of throwing him out the window.
Well,
He didn't stay around to do anything else in the apartment either. He just ran out with the other two.
And he had blood in various parts of his jacket that were consistent with dropping somebody out the window.
Well, Your Honor, most respectfully, I don't know where the evidence that the blood was consistent with dropping somebody out the window came from. What the criminalist said, and I won't have time to get to his qualification, but I'll rely on it. At one point and one point alone, he says the stains on Mr. Rise's jacket exhibit directionality. He never explains what directionality means. He doesn't say anything.
No, I guess I thought there was evidence, and I could be wrong, about that it was on the front of the jacket and on the sleeves of the jacket?
I think that's correct, Your Honor. But the criminalist also said that blood spray, blood spatter can go a distance of 6 feet, up to 6 feet. I think that the indication
Was this a smudge? Do you know?
it's just described as stains, Your Honor.
Well, do we have the, was the jacket introduced in evidence?
The jacket was introduced into
So
evidence.
we can look at it?
Yes, Your Honors.
I mean, do you agree that if it's a smudge as opposed to splattering, that makes a difference?
Well, certainly I've argued that one explanation is transfer, and the criminalist did say he observed transfer stains. But I also think that, Your Honors, that a spatter can or spray can be the result of merely being present. And I can see that
Now,
is...
that I can understand.
Transfer is different than spatter, correct?
And this was, yes, Your Honor, and this was described as a very bloody apartment. What if he came upon this and was forced to lie on the ground? What if he was backed up against a wall? We don't know the dimensions of this apartment. That's certainly an explanation for how that could get there. And as I've indicated, it only gets the Commonwealth the first element if they're proceeding on joint venture. And that is the element of being present. However, going back to Salemi, Salemi then doesn't habituate any of its usual haunts. And if this court or if the Commonwealth is focusing on the flight aspect, I submit that being present at a scene like this and seeing what occurred inside would prompt anybody to run, particularly if they were in that apartment. And this court has already looked at the flight in the case of Commonwealth versus Maza, where you had a defendant who was actually present where a body was found. And he shaved off his mustache, he fled to Vermont, and it was found that wasn't enough. So I would ask this court not to impose a different standard in a case like this, where the evidence is so weak. When you talk about what Mr. Rise may or may not have been carrying out of 951, something was wrapped in a sheet. Now, we know it wasn't the purported murder weapons, the firearms that were perhaps used to bludgeon the victim, because those were found 4 city blocks away, 20 feet away from the co-defendant Parish Phillips. We don't know what it was. We don't know whether it was bandaging a wound.
Why couldn't it have been one of the weapons and then they got transferred to the other?
Because I don't think there's any testimony of anyone seeing any transfer, and Mr. Rise was...
But you're just saying it couldn't. You said it couldn't be the gun, and I'm just saying it could have been the gun, and he gave it to someone else later.
Well, Your Honor...
But I agree, there's no evidence of that.
And in a case in which my client is doing a life sentence, I think the could have been, might have been, just isn't enough in this particular case.
I'm not suggesting that it is. I'm only quibbling with when you said it couldn't have been.
I understand, Your Honor. The fact is, again, when the Commonwealth will talk about joint venture liability, my client went in alone. The Commonwealth will say that Mr. Eccles said there was a difference of only 3 to 4 seconds when my client went inside. I submit, if you review the evidence, Mr. Eccles said he saw Mr. Rise go in, let in by Mr. Woods, who's inside as well, and we have no idea what Mr. Woods was doing inside, and we know there were at least 5 people, including the victim, inside, and no knowledge of who was positioned where and what they were doing. But Mr. Eccles then says after Rise goes in, he speaks with Rhonda Woods, then he sees co-defendant Phillips and another individual across the street. He watches them cross Blue Hill Ave. He watches them approach 951. He watches Woods let them in. I submit to you that that is a period well in excess of the 3 to 4 seconds that he says. And again, the point is that Rise went in alone. There is absolutely no evidence whatsoever of what Rise did inside that apartment. None whatsoever. And if you look at all of the cases, every case cited for joint venture by the Commonwealth, there is much more. There are statements by the defendants. There is
There's statements by the defendants before the commission of the crime.
Yes.
And afterwards.
Yes, Your Honor. Threats made, deteriorating relationships. Those are all what the courts focus on. Also, in those joint venture cases, we do know what each of those defendants were doing during the commission of those crimes. There are more issues such as the Bianco case, where the defendant is seen reaching into a car that goes into a lake, or the Semenda case, where the defendant is holding somebody, kicking and punching him when he's stabbed, or the case where somebody is shot by several people. Nobody knows who fired the fatal shot, but we know that one of the defendants has a firearm in that case and actually fires it. Here, we do not know what the defendant did inside 951. Now, there is a case that is cited by the Commonwealth versus Perez, that may be analogous to this case. It's a murder inside, I believe it was a hardware store or something like that, and there's blood found on dry cleaning clothing left by the defendant. And I submit to Your Honors, there's more even in that case than there is in this case, because there's also rope fiber found on the clothing, and there was a rope used to gain nighttime entrance into the place. Also, the defendant's glove was found.
Is that a joint venture case? I didn't read.
No, it wasn't a joint venture. It was an individual liability case, which also is something that I need to emphasize to this court. And there was also a glove belonging to the defendant found in a distant location near the victim's property. Now, I submit to you, if Mr. Rise was there with Mr. Phillips within 20 feet of the firearms and with property belonging to the victim, then I wouldn't be having this argument with this court. I'd be talking about something else. But we have nothing, and the man is doing a life sentence on nothing.
Well, we do have, what I think, but correct me, that the blood was, is that right? Consistent with the
victim.
The
Yes.
victim.
Yes, Your Honor.
The blood on his clothes.
And again, when the Commonwealth focuses on joint venture liability, that gets them solely to the mere presence argument. It does not get them to any other aspect that's required under joint venture liability. It doesn't get them entering with knowledge that another intends to commit a crime. He went in alone.
But
There's no dispute.
he went in alone, but it does suggest he was in that apartment where blood is everywhere. Clearly, the evidence is consistent with many, many stab wounds and injuries before getting dropped out the window. So mere presence, I mean, don't you think this sort of combination may vitiate the argument about just mere presence?
Not, Your Honor, in this particular case. In an apartment with blood everywhere, with the possibility of transfer, with testimony that spray spatter could go 6 feet, I submit to you that he could have been backed up against a wall. He could have been ordered to halt. He told the police he was the victim of a robbery inside there. They found his necklace inside there. That's all the Commonwealth can show, and they can't show that he was in a position to help out. How do we know? How do we know whether he was or he wasn't? And how do we know whether he wasn't just frozen by what he saw in there?
Who testified? Who testified to seeing him leave the apartment with the others carrying something wrapped in a sheet?
The person who testified, and the only person who testified, was a multiple-time convicted felon named Sean Eccles, who had said that he had ingested a quantity of cocaine the day of this. He was the only one who testified. No sheet was found, nothing at the time Mr. Rise was arrested consistent with a sheet.
And how long after this incident was he arrested? Within a half an hour, within an hour?
I believe it was within a half, I think it was even less, Your Honor. I'd have to go back, but I would ask the court to verify that as well.
Mr. Bailey, one question. He was, Eccles, the witness who identified him, saw Rise and two other men running out of the apartment?
Yes, he says they all ran out at the same time. 3 men, one unidentified, one his co-defendant, and Mr. Rise all ran out together. And I submit to you that that shows nothing other than wanting to get away from whatever was inside there. I don't think that necessarily at all shows consciousness of guilt, and certainly enough to support a first-degree murder sentence. Your Honors, I've also cited Commonwealth versus Morris, which was the clown mask one with a thumbprint on the clown mask. I have said there's more evidence in that case where somebody said the man in the clown mask looked similar to the defendant, and a car belonging that was seen driving away from the scene was similar to the defendant's car. In that case, while the court said the thumbprint was, my word, significant evidence, it wasn't enough. I think the court could do the same thing here. They could say, certainly...
This is in your brief, isn't it?
Yes.
Yeah, okay.
Certainly the blood is significant, but alone it isn't enough. I'll rely on everything else, but I do want to ask the court also to look at the closing argument in which the prosecutor said the people who were identified near where the weapons were recovered. I think combined with everything else,
Thank
Your
you,
Honors.
Mr. Bailey. Thank you.
very much.
Ms. O'Donnell?
Good morning, Your Honors. May it please the Court, Kristen O'Donnell for the Commonwealth.
Did the Commonwealth ask that the verdict slip be, that the jury mark specifically whether it was joint venture or principal liability?
No, Your Honor.
Is there a reason that they don't ask in cases like this?
I don't know why.
Wouldn't it help you if they did?
It would have helped.
Does anybody have a thought of doing that?
I think-
Routinely suggesting in these cases, then you can be upheld on either theory, and it doesn't have to go back if there isn't enough evidence on one?
Yes, Your Honor. I know this case was tried in 2002, and I think that the trend is now to ask for these types of verdict slips. I don't know why it was not done so here. The verdict slips did specify the 3 theories of murder, but not the principal joint venture. If I can start with the sufficiency of the evidence. Here, there was
And it would
sufficient...
be helpful if you're talking about which defendant?
Rise, Your Honor.
Rise, okay.
Yes. Here...
No, I understand that, but if you go to other arguments.
Yes, Your Honor, I will. Here, sufficient evidence established that Rise was a principal and a joint venturer. When you have a situation like you have here, where the evidence establishes that 2 people are culpable for a crime, but it fails to show who is the principal and who is the joint venturer, the jury is warranted in inferring that both are either the principal or the joint venturer. And that is the case here. There's an...
What about the third person?
Well, the Commonwealth doesn't need to exclude all...
I understand. Let me just give you this hypothetical. This is a drug. The victim is a drug dealer, and one, I suppose, might infer that Mr. Rise was a customer, correct?
That's a possibility.
Sure. And so he might have gone into that apartment as a customer, and he might have been in that apartment as a customer when somebody else came in and started attacking. Viciously attacking. I think who knows what the state, was there any evidence as to whether there was any cocaine or any heroin or anything else in Rise's blood when he was apprehended?
I don't believe there was any evidence as to
one way or
Rise.
the other?
Correct, Your Honor.
But he could have, participated in taking drugs while he was there, not uncommon. And so he's there in the apartment. Do we know how big it is?
The apartment, Your Honor?
Yeah.
I did submit in my appendix a chalk of the apartment, and there was a view, so the jury did see the apartment.
Big, small room where this took place?
There was a kitchen, a hallway, a living room, a den, a bathroom, a long hallway, and
Blood all over.
the blood evidence that was described, blood everywhere in the kitchen. There was spatter in the kitchen and the door to the kitchen. There was some transfer on the hallway, blood in the hallway, and various stains in other rooms of the apartment.
Fair to infer that the victim tried to get away?
I think that's a fair inference to
Could have
make.
been running, flailing his hands, desperate situation,
Or dragged to the window.
or dragged,
Yes.
right? And Rise is there, not participating. I mean, I'm just trying to look at it the other way.
Yes, Your Honor, and I think the evidence here, it's not reasonable to show that he was merely a bystander, and I base that on first the entrance into the apartment. He enters the apartment, and 3 to 4 seconds later, I believe, is the
Well,
testimony
he
of
enters
Mr.
the
Eccles.
building. Do we really know
The
he enters
building.
the apartment?
He enters the apartment building. We know from the blood evidence that he was in the apartment.
Yeah, no, there's no, I don't think that I heard defense counsel saying that he wasn't, well, he may have, was not in the apartment.
Right, so we have him entering the apartment. 3 to 4 seconds later, we have Phillips and the unknown male enter the apartment. Mr. Rise is in the apartment for the entire course of this beating, this stabbing. He doesn't flee any time beforehand. He flees only seconds after the victim has been dropped to his death. And when he is discovered, he is covered in blood.
And if he were seeking to flee, and some of the other men were engaged in throwing the body out the window, which took at least 2 people, then wouldn't that be the time to flee?
Exactly.
While the others are engaged in dropping the body out the window. If he wants to get out of there, that's the time to do it?
Exactly, Your Honor. And also, the blood evidence, I do want to touch on this. The clothes were all entered into evidence, and Mr. Gorn testified to the blood evidence on Rise's jacket. There was a large stain on his left sleeve. It was given in centimeters. I believe it's 10.5 by 9 inches. Large stains on his right sleeve, stains on his chest, stains on his back. On the shirt that he was wearing underneath the jacket, stains on the cuff, and also a large stain 5 inches by 2 inches on the bottom of the shirt. There was also some spatter on the jacket. This indicates not only that he was in close proximity, I think the jury can rely on this to conclude that he was a participant in the beating and the stabbing, but also that he held the victim and likely dropped him to his death. This blood evidence tends to negate that he was an innocent bystander, and it's on all of his clothing.
How does that compare with the blood that was found on Mr. Phillips' clothing, for example?
Yes, there is a blood on Mr. Phillips' clothing as well. The most extensive testimony was regarding Phillips' jacket. There is transfer stain, large stains on there as well, 20 by 9 centimeters and 15 by 11 centimeters, and it's described as both spatter and transfer on his jacket.
I have a question about the DNA evidence.
Yes.
You say, this is page 14 of your brief, that there were blood stains found all in these various places, and then you say the victim's DNA was included as a possible source of the blood samples extracted from all of these items except one. And then you give the statistics. The DNA found could be expected in 130,000 African Americans, 1 in 1,300 Caucasians, a very big difference, and 1 in 1,600 Southeastern Hispanics. But then you never tell us what race the victim is. Wouldn't it be helpful if you did? Or at least I didn't see it.
The victim was an African American.
Okay, but I think in your brief where you give these statistics, it would be helpful if in the same paragraph you would mention that the...
I apologize, Your Honor,
Yeah,
that I
I'm
didn't
just-
include that.
I'm just saying at least I haven't read the transcript yet, and when I was reading the brief, it was difficult to put the statistics into a framework. Okay, thank you.
In addition to the bloodstains, I just also wanted to touch on, there is consciousness of guilt evidence. Not only did did defendant Rise flee with Phillips, but when he was spotted jogging down the street by officers, he stopped jogging, he started walking. He didn't say at that point, I'm a victim, I've been robbed. What he said was, the boys that shot that dude ran down here, pointed in another direction, and then ran away from the police.
There's only mention that the shots were heard, but I take it the victim was not shot.
The victim was not shot. There was no ballistic evidence found. There was, the 2 guns that were recovered were the Lorson and the .380.
And had they been fired?
Only one of them, the Lorson, I believe, was inspected and found not to have been fired. There was no inspection done on the .380. There was also testimony from Sergeant Keeler that there were 2 other guns mentioned by another witness in this case, Courtney Woods.
So is there any evidence that there was a shot at all?
Well, there's there's no ballistic evidence that there is a shot at all, although one of the guns mentioned was a revolver. So it's possible there could have been gunshots and no ballistic evidence was found.
Also, didn't the police come because of a call of shots fired?
The original call was for an unknown, and then the call that came thereafter was for possible shots fired, and I think that was based on the conversation with Mr. Eccles, who said he heard shots fired.
But the ME testified that the injuries he observed were consistent with force inflicted with a blunt instrument, possibly a gun.
Yes, that's true. The lacerations, that's true, Your Honor. And also, if I could, so there's also Phillips' consciousness of guilt evidence that would play into this, as well as the wallet that was found in his pocket.
But that doesn't help on
Well,
Rise.
it does help in that if there are two people culpable for the crime, the jury can infer that both were the principal and the joint venture. It's overwhelming circumstantial evidence that both of these men committed this crime. And if I might just touch, if there are no other questions on sufficiency, I just touch quickly on the closing argument my brother brought up. Here, the prosecutor properly urged the jury to believe Mr. Eccles, and she didn't do so because he merely came and testified. What she did was tied what he said at court, his testimony, with evidence that corroborated that. And in doing so, she talked about there was some question as to whether or not the victim was dropped from the window, whether he dove out. She pointed to the blood evidence on the apartment, as well as the fact that no glass had been found within the victim's wounds or on the victim's clothing. She later goes on to say that Mr. Eccles got up and admitted what he is, who he is, told not more than what he saw, told what he saw, and then is it a coincidence that the people that he observed running from the crime scene were covered in the victim's blood? She does go on to say, is it a coincidence that the people he identified, and then she pauses, Silverio's blood is on the gun 25 feet away. She never states that it was Rise that was found 25 feet from the gun. At most, this is an ambiguous statement.
I take it the evidence was clear that Rise wasn't found anywhere near the gun.
Exactly. As my brother concedes in his brief, the evidence was clear that it was Phillips who was found here. In fact, 3 pages earlier in her argument, she states this at least twice, and numerous officers testified to which defendant was found in which location.
Could I go back to the sufficiency?
Yes.
I apologize.
That's okay.
But I want to take off on the question the Chief Justice asked Mr. Shea, and that is, what do you think I looked at some, I'm not sure I looked at all of the cases that you cited for purposes of support that this evidence is sufficient. What is the strongest case for you? Because I thought a lot of them had a lot stronger facts than this case.
I think it is very difficult to find a case of sufficiency where we're talking facts that matches up quite perfectly. I think the best case is probably Commonwealth v. Cohen. I believe it's 412 Mass 375. And although my brother is right that some of the cases that I talk about, there are some statements maybe that a defendant made beforehand. But while we don't have statements here, what we do have is a lot of physical evidence. We have the victim's blood.
And is Cohen a joint venture case?
Cohen is a joint venture case. It's a case where there were 2 defendants and 2 victims. It was a shooting. That no weapon was discovered, and I believe, I'm not 100% certain of this, but I don't even know if there was testimony as to which defendant was holding the gun. I'm not sure that there was even testimony as to that. But they were in the same location, and it could be reasonably inferred that either one of them fired the fatal shot. So
I take it that presence is there, and that you would point to the timing of when he left the apartment and the extent of and differing kinds of blood on him that were linked to the victim
In carrying a sheet.
are sufficient to sustain the conviction.
yes, and yes, Your Honor, that he fled the apartment carrying something wrapped in a sheet.
In consciousness of guilt when he was confronted by the police.
And exactly, Your Honor, thank you.
I have a question on a different subject. I probably should have asked the defendant, Phillips, but he makes an argument about the defendant. It seemed to me that his argument is that the defendant must know at the start of the attack that the co-venturer is armed, and that it isn't enough if he learns of the gun during the attack. I'm not aware of any case that indicates that the co-venturer must know of the weapon at the start of the attack. Are you?
No, Your Honor, I haven't found a case that says exactly that it would be insufficient if what happened here happened. Clearly here, he had This was a prolonged attack, as indicated by the numerous injuries to the victim. He would have had ample time to withdraw. There's no way he could not have known about this weapon during the attack.
It's not a single-shot case.
It's not a
where-
single-shot case. One case I didn't cite in my brief that I did find last night, and I'd be happy to send a 16L letter. It's I believe it's Commonwealth v. Sexton. It's a case of assault and battery with a dangerous weapon, co-venturers, where the defendant kills the victim, I believe, by banging his head into the pavement. And the pavement is the dangerous weapon, and clearly the defendant doesn't bring the dangerous weapon to the event. And I believe it's this court that found that the co-venturer would have
Do you know
had
what the site is?
knowledge. I believe 425 Mass 146.
Can we talk a little bit about the identification? Were you going to get to that?
Yes, we can, Your Honor.
Why, what steps, if it, I mean, isn't this the classic suggestive identification? The identifying witness knows in advance that the police have got the man, so he's going to, there are two officers there, he's in handcuffs, spotlight on him. Isn't this the classic suggestive?
No, Your
do.
Honor, respectfully, I disagree. Here, if we look at the whole context, first, as I think someone pointed out, there were a series of 6 show-ups here. The defendant looked at 8 different individuals. I believe my brother talked about testimony about how Eccles believed that 3 of the individuals were coming out of a liquor store, but there was also testimony from the officers. I believe that 4 or 5 other officers were around those individuals. While it's true that the defendant was handcuffed, and that maybe the witness was expecting to see one of the perpetrators. That's true probably in any situation, that you're expecting to see someone that matches the description. And that's why you're there, to identify someone who likely matches the description you've provided. And again, there are cases that say merely being in handcuffs or merely being surrounded by officers doesn't make it so unnecessarily suggestive.
There was one person seen after Phillips and Rise, correct?
There were a total of 6 show-ups. There were the 3 individuals
three,
first.
and then 2,
then
and
Phillips.
then 1 more.
Rise was the 4th, and then 2 after Rise.
Okay.
Because they were looking for a third person.
They were, exactly, they were
And
trying.
and those 2, were they?
2 after Rise?
Yeah.
Yes.
Were they?
In handcuffs?
Yeah.
Neither of
or
the-
in custody. in any way?
Neither of them were in handcuff. I believe, and I have to double-check this, I believe there is information that the takedown lights or the alley lights, I'm not sure which, were displayed. And I believe that there were officers around them. I think one of them, there was a BPD officer and an MBTA police officer. I'm not sure that the testimony is clear exactly where everyone was standing and how it was.
So
Let me
Mr.
ask-
Phillips,
let me ask
Mr.
the
Phillips-
question.
excuse me.
Sorry, let me ask the question differently. Would a citizen conclude from that, from the 5th and 6th show-ups, that these were people that the police might suspect?
Yes, Your Honor. I think that the inference there is fair, that these people were stopped by the police because the police suspected that they
It was not driving by in a car and seeing somebody walk down a car. Here
No,
they stopped,
these
they're
were
surrounded by
officers who had
police.
stopped
Yeah.
people who they thought matched the description.
And was Mr. Phillips the only one that was handcuffed?
I think Phillips and Rise were both handcuffed.
And was Rise also identified in the show-up?
Yes.
But Mr. Eccles knew Mr. Rise?
Yeah.
Yes.
Okay.
Yes. Are there any other questions?
Thank you, Ms. O'Donnell.